when do you want to start your discussion on that? Bottom line is, these McGirt, Murphy before it, now the Bosse, the Hogner case, Sizemore, no tribe is a party to these cases. These cases are brought by criminal defendants who are challenging the jurisdiction of the government that's prosecuting them. These issues have been essentially on the table for generations. No tribe pressed for the litigation of clarification of the reservation status or the boundaries. Individual defendants did. Once that became a live round, each tribe has an obligation, just like the state has, to step forward and make sure that the law and the legal history is brought accurately to bear on any question that's presented to the court. So each of the tribes in this instance have done that. And I'd refer you to the amicus brief that Chickasaw joined with Choctaw Nation and several former state officials filed with the U.S. Supreme Court in both the Murphy and the McGirt case. And we made the argument that, yes, indeed, the law is on our side on this. Our legal history is pretty clear. And in this first instance with the U.S. Supreme Court looking at this issue, we think it's clear that our reservations have never been disestablished. The next question is, what do we do about that? And our position, as we laid out in our brief, is we compact with the state on all manner of things. The issue of tribal governments in Oklahoma is actually a source of strength for the state. You look at what the tribes do in terms of government services, what we do in terms of investments in communities. You look at how well we've been doing in distributing the vaccine in the middle of this pandemic. The tribes are a strength and asset for for the state. And you look at our history here, back in the 80s and 90s, there was a lot of litigation between the tribes and the state over all manner of jurisdictional conflicts. And in the mid-90s, we realized, you know what? Courts are pretty good at telling us yes or no to various questions. They're not very good in telling us how to get along. In order to get along, that takes statesmanship, that takes leadership, that takes engagement, and it takes meaningful sharing. And we do that through compacts. So as we laid out in the brief to the court, we believe that's how we address these issues. So to the extent there are challenges presented by our effort to remedy generations of jurisdictional error, the response to that needs to be working together. So Chickasaw Nation, heck, we've spent a lot of time over the past few years investing in updating our criminal code, making sure we've got good police force, working on our prosecutorial system, working on our court system. And we've got cross-deputation agreements with law enforcement throughout our boundaries. We're working on getting everybody signed up so that we all have the legal authorizations to do what we need to do. So to the extent there are folks talking about who's to blame for the situation, we don't really see that as a constructive or productive conversation. The real question is, what are we doing now? How are we moving forward? Are we moving forward with common interest for public safety and effective law enforcement? Or are we going to try to bog ourselves down? The court has ruled. We need to work together in moving forward. Yes, and it's funny because the first question is, like, do we have a problem? And let's talk about what the problem might be. There's no jurisdictional gap. Someone has jurisdiction over every crime that's committed. Crime rates aren't going to change. The question is allocating the law enforcement resources to meet who's going to have responsibility for the crimes. So yes, because of the Major Crimes Act and the General Crimes Act, the federal government has exclusive jurisdiction over certain crimes. They have concurrent jurisdiction with the tribes over another set of crimes, and then the state has exclusive jurisdiction over a whole other set of crimes. So all the crimes are covered. It's just a question of who prosecutes. Now, the federal government does not have a great track record of being the law enforcement presence in Indian country. So that suggests a challenge. You look at the number of murders that the Northern and Eastern District now have on their dockets today following the McGirt and subsequent rulings versus what they had in previous years. it's a challenge. Is the federal government up to it? Yes. Will they allocate the resources? That's a Justice Department question. From the perspective of the Chickasaw Nation, this is our community. Our goal and objective is to make sure that everyone's safe and law enforcement is effectively deployed. We work well with the federal government and the state government, but we don't necessarily see a direct value in the state being forcibly ejected from the field by operation of federal law. We didn't choose that. We didn't bring the case. We didn't choose the consequence. Federal statute did. We can compact with the state right now on policing, on jailing, all the rest of that. Federal law, when you ask what role Congress has, Congress, we think, has a very narrow and particular role. Because those federal statutes provide for exclusive federal jurisdiction, our hands are tied. So if we, let's say hypothetically, the Bosse case, that's the case that came down here in Chickasaw Nation. It's a non-Indian offender who brutally murdered a Chickasaw family. We take no pleasure in the fact that he has now been able to capitalize on the McGirt ruling and have his state conviction tossed out. We grieve with the family on that. But our jurisdiction is what our jurisdiction is. We would rather be able to sit down with the state and compact and figure out an appropriate way that we can work together as the primary jurisdictions on the ground as to how to handle these cases. But we would need Congress to enact a statute that would allow us in that narrow subject area to do a compact on that. Okay, well, the whole question of must be done suggests that we can't do it otherwise. The way it works everywhere else, the federal government would bring the cases. The tribe prosecutes what it does. We've brought almost 70 prosecutions to court since Bosse came down just 3 weeks ago. So we are stepping in, we are prosecuting crimes. I don't have the statistics on where the feds are on it, but they do this work too. So I challenge the notion that there's some irredeemable problem that there's only one solution to. There's all sorts of solutions. The one we select and are advocating for is we want Congress to let us compact on it. And if Congress does not allow us to, the federal government's going to have to step up, and we're going to be pushing them to do so. And we would look to our state partners to likewise be working with us to make sure the federal government is appropriately pushed to do what it needs to do. The facts are what the facts are. We're going to have to work through on it. I mean, and those are two pretty workable plans, and we're working both of them right now. And I can't, given the public commitment the state, the tribes, the federal government have in law enforcement and public safety, no one's thinking casually about this. No one's cavalier about it. We recognize that there's a lot of work involved, and we're going to get it done. There's going to be creative minds applied to this. So, for example, let's say Congress doesn't act. Well, maybe we explore more enhanced compacts with the state of Oklahoma, where the state exercises tribal jurisdiction and we contract with officials of state government to perform some of those functions. There's different ways we can do it. But the bottom line is Indian country jurisdiction is driven by federal law. It is what it is. The legal history of Oklahoma is what it is. Right now, we're finally getting back to addressing these matters in accord with what the law is. And we just need to make sure the resources follow where that takes us. I hear versions of that. I also encounter folks regularly within the Chickasaw Nation who kind of half-jokingly say they kind of wish the tribe would just take over. The working for the Chickasaw Nation kind of spoils me as a lawyer. We do a lot out there. We have just in the criminal justice system, we have a pretty substantial police force. We've got a professional team of prosecutors, and we've got a court system that we're growing and expanding. Just a few years ago, actually, just as circumstance would have it, We bought the old federal courthouse down in Ardmore, and happily we've not renovated the building yet, so we haven't converted it from its former purpose. So now we have our judicial complex up in Ada, and we're expanding now down in Ardmore with a new judicial complex. When you look at what we've accomplished in healthcare, housing, job training, the mission of the Chickasaw Nation is to enhance the overall quality of lives of Chickasaw citizens. And we do it every day. There's a lot of mythology in both the public perception and the law when it comes to tribes. There's this myth of this disappearing Indian, that somehow tribes are not a part of today. When Governor Stitt pulled together his commission on cooperative sovereignty, one of the criticisms that was leveled on the report that came out of that, and I believe it came from Chief Hoskin out at Cherokee Nation, was Governor Stitt is very comfortable talking about tribes as part of the past. What he needs to recognize is tribes are part of the present, and they're going to be part of the future. And that's a very powerful message. And when you work in and around Indian country and you see what the tribes are doing, a lot of those arguments become laughable. To potentially say something I shouldn't, it's also kind of troubling to hear those arguments made when you look at some of the stuff that happens within state and local government. Incompetence happens everywhere. No one government or group has a patent on that. I'm proud to work for the Chickasaw Nation and Governor Bill Anatubby, and we set a pretty high bar as far as the work we do. So anyone who wants to suggest that we're not up to this clearly doesn't know the Chickasaw Nation or what they're talking about. Parties to litigation, when one party is aggrieved, they have a couple different options. They could appeal from the ruling. The Oklahoma Court of Criminal Appeals is like the highest court for criminal matters here in Oklahoma. So if the state wants to appeal from it, they've got to go all the way to the U.S. Supreme Court, and that's a pretty big lift. So there's an alternative process, and it's not exclusive. You can do both, but you can petition for rehearing, which is essentially saying, hey, court, we don't think you really thought hard enough about this, so we're asking you to take another shot at it. Under the court's rules, the simple filing of that petition automatically stays what's called the mandate. The mandate being the legal order compelling everyone to follow what the court just said. When the court originally handed down the Bosse ruling, they had a 20-day stay on the mandate. That would have expired today. So by filing that yesterday, the Attorney General stayed the mandate until such time as the court resolves the case. Attorney General Hunter is a person he's an honorable person of goodwill. He called us, gave us a heads up, told us who's going to be filing this. And we talked through what that would mean. Chickasaw Nation then filed yesterday, and we don't have any right, we're not a party to the case. So we had to file a motion asking the court's permission to weigh in on it, and the grounds for that being, hey, this affects us. We might not be a party to the case, but this relates directly to our sovereignty, so we think the court should hear from us on this question. And then we filed, if the court grants us our motion, we gave them a brief where we don't really argue it all that much, but we just don't think the Attorney General is right. We don't think there's reason to rehear the case. However, transitioning from the jurisdictional errors of the past several generations to what federal law requires is not something you do with a flick of a switch. There are multiple police and law enforcement offices on the state, federal, and tribal level that are all coordinating right now. And there are hundreds of criminal defendants that are now making motions for release in courts throughout Chickasaw Nation. We've done a really good job coordinating to date, but if the Attorney General is going to go and file a petition for rehearing, we said, hey, court, if you give us some additional time, we're going to do an even better job. So we think the public's interest would be served by extending the stay on the mandate, but for a predictable amount of time. If by filing the petition they get an automatic stay, we don't know when that lifts. It could be tomorrow. It could be 2 months from now. We're trying to implement these programs on the ground in coordination, intergovernmental coordination. We'd prefer something more predictable. So we suggested, why don't you just give us a 60-day stay, and then we'll know at the end of that 60 days what the rules are and where we go.